Equal protection to all. No state shall make or enforce any law which shall abridge the privilege or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. We previously defined civil rights as the substantive application of equal protection under the law to individuals. Prior to the passage of the 14th Amendment, the Bill of Rights was the only protection citizens had. Even the principles outlined in the Declaration of Independence, natural rights, inalienable rights, and the statement, all men are created equal, suggested that civil rights should be an integral part of our government. But the issue of slavery quickly brought to a stop any fulfillment of these principles. The Dred Scott case in 1857 established that slaves were property based on the Due Process Clause of the Fifth Amendment. The significance of the 14th Amendment is that it seemed to nationalize the meaning of civil rights. On the surface, it seemed that states could no longer discriminate against their citizens. Yet one of the first key court cases after the passage of the amendment had a chilling effect on any thought of nationalization of the Bill of Rights. The slaughterhouse cases in 1873 involved suits by individuals against states, accusing the states of the denial of property rights under the 5th and 14th Amendments. The Supreme Court dismissed the suits and ruled that the intent of the 14th Amendment was to protect the freed slaves, not incorporate the Bill of Rights. Yet when the Congress passed in 1875 the first Civil Rights Act since the Civil War, the Supreme Court did not follow the principles set down in the slaughterhouse cases. When a provision of the Civil Rights Act, which established the legality of access to public accommodations, theaters, hotels, and other public facilities, was challenged, the Supreme Court ruled that aspect of the Congressional Act unconstitutional. Its logic was that the 14th Amendment applied only to the states operating under cover of the law. But the definitive action by the court in Plessy v. Ferguson in 1896 put the issue to rest. When Homer Plessy challenged the Louisiana state law that created two classes of railroad fares, the Supreme Court, using the fact that the passenger train had only an intrastate route, ruled that separate but equal facilities were constitutional under the equal protection provision of the 14th Amendment. Even after the Supreme Court case nationalized the Bill of Rights in the Gitlow case, described in Lesson 5, it reversed itself in a significant due process case, Paughco v. Connecticut. This case, involving the issue of double jeopardy, gave Connecticut the right to try an individual a second time. The concept of applying the 5th and 14th Amendments' due process provisions to citizens who felt that their privileges and immunities were being violated by the state was rejected. The concept of ordered liberty became the criterion for any incorporation of the Bill of Rights into the 14th Amendment. Then how did the 14th Amendment finally become the basis of the civil rights movement? It took the Supreme Court over 50 years to finally reverse Plessy. Brown v. Board of Education signaled the beginning of equal protection under the law for African Americans. There were, however, other significant First Amendment and due process cases before Brown, which started the process of incorporation. Key court cases: Gitlow v. New York, 1925, freedom of speech. Neer v. Minnesota, 1931, freedom of the press. Powell v. Alabama, 1932, access to a lawyer in capital cases. Dijon v. Oregon, 1937, freedom of assembly. Cantwell v. Connecticut, 1940, freedom of religion. Wolf v. Colorado, 1949, unreasonable search and seizure. After the Brown decision, an activist Supreme Court used the principle of incorporation in many of their decisions to promote 14th Amendment due process rights and equal protection under the law. The criteria they used were threefold: reasonable classification, the distinctions drawn between persons and groups; the rational basis test, if the legislative intent of a law is reasonable and legitimate and serves the public good; and the strict scrutiny test, which places the burden of the states to prove that laws that discriminate fulfill a compelling government interest.